We're excited to show you our native speech capabilities.
Stop what you're doing. Look at that title. Emergency Ruling, Supreme Court's 5-4 decision to freeze Trump's $454 million bond. You click this because you know what that number means. $454 million. It's not just money, it was the sword of Damocles hanging over our real estate empire, threatening to carve off pieces of the Trump organization, maybe even the seizure of properties. It was the moment that New York Attorney General Letitia James had warned about. The deadline was looming, the clock was ticking, and the possibility of a financial meltdown for a former president was real. Now, the key word in our title, the one that stops everything, is freeze. But here's the honest, raw reality of how high-stakes legal news actually works. The narrative you see in that headline is a snapshot of an emergency that almost happened. And what really transpired in the courts is far more complex and, frankly, far more interesting than a simple headline. Because the ultimate question wasn't about the money. It was about whether an American court could enforce an impossible bond, and what that means for your rights and for the entire U.S. financial system. Today, we're diving into the untold story behind the number, the judicial drama, and the precise legal maneuver that put the brakes on a political and financial explosion. So let's rewind. How did we even get to a $454 million debt? It all goes back to a New York civil fraud case brought by Attorney General Letitia James. The ruling, delivered by Judge Arthur Engoron, found that Donald Trump and his executives deliberately inflated the value of their assets, everything from Mar-a-Lago to his Trump Tower penthouse, to get better loans and insurance deals. The judge didn't just fine him. He ordered a massive sum in what's called disgorgement. That's the legal term for giving back the ill-gotten gains, plus interest. Now, in the American legal system, if you want to appeal a massive judgment like this, you typically have to post a bond. This bond is essentially an insurance policy that says, I promise to pay if I lose the appeal. The original ruling required a bond that was even higher than the judgment, hitting close to $464 million when you factored in interest and the insurance company's requirements, which is usually 120% of the total. Here's where the story goes from a simple lawsuit to a massive legal crisis. Trump's legal team approached 30 different surety companies. That's 30 major financial institutions. And the answer they got back from all of them was basically no. This isn't just a rich guy problem, folks. Think about that for a second. 30 companies said no. Why? It wasn't just the size of the bond, though $550 million in collateral is huge. It was that these underwriters wouldn't accept real estate as collateral. They wanted cash or cash equivalents. If you're a real estate mogul, where is your cash? It's tied up in buildings. This is the classic cash-poor, asset-rich problem. And this is the moment the lawyers said in court, it's a practical impossibility to post this bond. The deadline was March 25th. That Monday became the focus of the entire political and financial world. If Trump and his lawyers failed to post the bond by that deadline, what was the very next step? The New York Attorney General's office, remember, had already warned they were prepared to seize assets. We're talking about the potential seizure of bank accounts, liquid assets, and eventually the most iconic properties in his portfolio. The media, the public, everyone was watching for that midnight deadline. The tension was palpable because this was a historic legal moment. A court essentially saying, pay up or we start taking your property before your final appeal is heard. But here's the crucial legal nuance that changes everything. The courts knew the $464 million requirement could be viewed as a manifest, irreparable injury, meaning the damage caused by having to sell assets just to appeal might be irreversible, regardless of the appeal's outcome. This is where the Appellate Division, the state's intermediate appeals court in New York, steps in. Not the Supreme Court yet, but a crucial judicial emergency break. This court had to weigh the Attorney General's right to enforce the judgment against the defendant's fundamental right to a meaningful appeal. Engagement question. Quick poll in the comments. If you were one of those 5 judges on that appellate panel, knowing the political firestorm, would you have stood firm on the $454 million or hit the pause button? Let me know below. So the actual emergency ruling didn't come from the U.S. Supreme Court, and it wasn't necessarily a 5-4 split, but it was a deeply significant, high-stakes judicial intervention that saved the day for Trump, at least temporarily. On the Monday deadline, the Appellate Division justices ruled. They issued a stunning decision. They agreed to stay, that means to halt collection of the massive $454 million judgment, but on one condition. The required bond would be slashed from over $464 million down to a much more manageable $175 million. This was a massive, sudden, and complete shift in the game. It was a victory won at the absolute last minute. It prevented the immediate financial seizure that everyone had been anticipating. Why did they do this? The judges essentially acknowledged the practical impossibility argument. They realized the original bond requirement effectively blocked the right to appeal, a cornerstone of the American justice system. The court was saying, we agree he has to face accountability, but we can't make the terms of his appeal literally impossible. This ruling was less about whether Trump was guilty of fraud and more about the constitutionality of the penalty itself. Now that the pressure was off, Trump was able to secure the $175 million bond using the help of Don Hankey and the Knight Specialty Insurance Company. But even that smaller bond, that lifeline, created its own legal drama. The AG's office quickly objected, questioning the very validity of the insurer and demanding proof of funds. This is the constant battle. One legal action simply spawns the next. Let's talk about the ripple effect. Why does this matter beyond just one wealthy individual? First, the precedent. If a court can demand an impossible bond, it essentially denies an appeal. That is a threat to due process for all citizens, rich or poor. The appeals court stepping in was a check on judicial power, a reminder that the penalty must fit the crime and the terms of appeal must be reasonable. Second, the future of the case. This bond freeze was just the intermission. The actual, final, ultimate appeal over the entire $454 million verdict is still coming, likely heading up to the State Court of Appeals, and eventually, yes, the U.S. Supreme Court could be involved on a constitutional question like the Eighth Amendment's excessive fines clause. The $175 million bond simply buys time. It doesn't win the war. The next flashpoint won't be the bond. It will be the actual appeal hearing itself. We need to watch for the arguments around the statute of limitations. Did the Attorney General wait too long to bring the case? And the fight over the fundamental nature of disgorgement. Is forcing someone to give up profits when the loan recipient suffered no loss actually legal? These are the deeper questions that determine the fate of the original judgment and will set a precedent for fraud cases in New York and possibly nationwide. The legal war is far from over. So there you have it. The emergency ruling in our title wasn't the final gavel of the Supreme Court, but the desperate last-minute intervention of an appeals court to prevent a legal and financial catastrophe that would have denied the right to appeal. The 5 judges on that state panel acted as the crucial check on an unprecedented judgment. The $454 million is still on the line. The legal war is still being fought, and the implications for the separation of powers and the protection of private property in America are enormous. If you want to stay ahead of the curve, if you want the real breakdown of what's happening in the courts and not just the screaming headlines, you need to subscribe right now and turn on that notification bell. Because when the next shoe drops, when the final appeal is heard, you want this analysis in your feed first. Leave a comment below. Now that you know the full story, do you think the appellate court made the right call by slashing that bond to $175 million? Or should they have let the $454 million deadline stand? Let's discuss it. Thank you for watching. We'll see you in the next one.